Welcome back to For the Defense. My name is David Oscar Marcus. And the word legend gets thrown around a lot. But today we literally have a living legend, Phil Hubbart, around on the show. He is one of the true greats in criminal defense. He revamped the Miami Public Defender's Office, hiring folks like Roy Black, H.C. Smith, Jack De Niro, others. He then became a third DCA judge. But in between that, he represented Freddie Pitts and Wilbert Lee, and he wrote a book about it called From Death Row to Freedom, The Struggle for Racial Justice in the Pitts-Lee Case. I really recommend it, and I'll be talking about it today with Phil Hubbart. We did this talk at an event at FIU Law School that Scott Fingerhut and H.T. Smith put together. They're really doing great things at that law school. It's amazing, the trial program they have, the students they have. And Scott and HT really have done wonders there. Again, I highly recommend Phil Hubbart's book. Let's get right into it in our discussion about this amazing saga of Freddie Pitts and Wilbert Lee in For the Defense next. When I was preparing for this today, Phil, the quote that came to mind, and one that you mentioned in your book, is Martin Luther King's quote, "The arc of the moral universe is long, but it bends towards justice." That is this case. But before we get there, let me just tell you who this legend is sitting next to me, Phil Hubbart. He started out as a debate champion in college, and many great lawyers start off in debate, either in high school or college. Phil's no exception. He went to Duke Law School, got his LLM from Georgetown, started out, as you heard, as a public defender, but not here in Miami. Started out in D.C., then came to Miami in private practice and became a public defender, but not just any public defender. He became the elected public defender in 1970 and really changed the office. Before Phil, the office was like 6 part-time public defenders who came in a couple times a week, pled out all of their cases, never went to trial, and Phil changed the office, changed the culture of the office. You heard from HT, one of his young recruits was Roy Black. Roy Black said this about Phil Hubbart. He said, "This radical change in the justice system was the product of one man, Phil Hubbart. The Justice Building was renamed after the former state attorney Richard Gerstein. If there were any justice, it would be named after Hubbart because it was he who brought justice to the building." I mean, pretty incredible. He became an appellate judge on the 3rd District Court of Appeals in 1976. And like I said, it's pretty rare to be in the presence of a legend. We are in the presence of one today, and you guys are very lucky. We're here to talk about his book, From Death Row to Freedom, The Struggle for Racial Justice in the Pitts-Lee Case, about his representation of Freddie Pitts and Wilbert Lee from 1965 to 1975. So, Judge, let's start out. Just if you could, tell us a little about who Freddie Pitts and Wilbert Lee are, who they were, and what they were charged with, to give a little background about the case.
Okay.
And if you could speak up for everybody.
Well, thank you very much for that wonderful introduction, David. Freddie Pitts was 19 years old at the time of this case. He was in the United States Army. He was stationed outside of Port St. Joe in the Florida Panhandle, the eastern end. Wilbert Lee was a longtime resident of this little town, about 4,000 people, Port St. Joe. It's on the eastern end of the Florida Panhandle. And he was a longtime resident of Port St. Joe. And from time to time, the two of them knew each other slightly. Every once in a while, Freddie Pitts would get leave from service and would come into town, and so he got acquainted with a lot of the black people in that area. That's how they were sort of acquainted with one another. Now, what happened was there was a late one night, July 31st, 1960,
a long time ago, in a galaxy far, far away.
Okay. At any rate, there was a gas station holdup in a little gas station outside of Port St. Joe. This was 1963. I'm sorry, lapse on the date there. July 31st, and the early morning hours of August 1, 1963. And the station was held up. The two attendants were kidnapped, taken out in the country, and a couple days later they were found killed in the countryside with a bullet hole in both of their heads. They'd been executed. So that was the basic murder involved in the case. There was only one person living in Gulf County at that time with a record for armed robbery. Only one. His name was Curtis Adams, and he was well known to the police. The local police officer, Wayne White, Deputy Sheriff Wayne White, knew him personally and knew he was quite capable of committing an armed robbery. Yet, he did nothing about it. Wayne White did not pick him up, didn't question him. He was white, and he ignored it. Instead, they concentrated on a bunch of black people that they thought were involved in this thing. Now, this was at the height of the civil rights crisis in the South, 1963. Can go in great detail about the details of that. But my God, I mean, that was a hell of a time. But at any rate, what happened was that Pitts and Lee were having a party together with a number of other black people in that area, and Lee needed to make a phone call, long-distance phone call concerning some funeral arrangements he needed to make. And so he didn't have a telephone in his house, and so he and Pitts and a number of other black people piled in the car and went down to the mojo station to make this telephone call. And while they were there, one of the women asked for permission wanted to use the bathroom, and the two attendants wouldn't let him do it because it was segregated. It was for white people only. And there was an argument over that. That's all that Wayne White needed to know. There were white people in the station at that time as well. But of course, they were contacted, they were talked to, but they were never arrested. But once Wayne White found out about that argument, that was it. That was the motive for murder. That was the motive for the whole thing, and he ignored Curtis Adams. Curtis Adams, now mind you, the only person with a record for armed robbery in this area, the logical suspect. What does he do that night? He escapes from Port St. Joe with his girlfriend. He tells his girlfriend at the time, that night, what he had done. He'd murdered these two people in order to get some money so they could leave town. Then they went down to Fort Lauderdale. 16 days later, this same man, Curtis Adams, goes out and murders another gas station attendant. The same modus operandi, David, the same modus operandi.
You're getting ready to give your closing argument, Phil.
Yeah.
I love it. I'm ready to vote. But before we get to Curtis Adams, and
okay,
maybe we're jumping the gun a little bit, after Pitts and Lee are arrested,
okay,
do they get a lawyer?
Well, no, they do not get a lawyer. They do not get a lawyer. They're interrogated at all hours of the day and night.
Okay.
As this goes on for a week, well, in the midst of it, the one judge up there with a conscience, and I like to quote him later, Fitzpatrick said, we've got to have a court hearing for these people. So they had a court hearing. And these two men were then taken over to this courthouse. And this is unbelievable. Both of them were handcuffed. Both of them go into the courthouse. A man comes up to him, David Gaskins, who's a lawyer who's been appointed by the judge to represent these two men. He does not say he's a lawyer. He just starts to talk to them. And both these two men assume that there's some kind of court official of some kind. And he just says, this is the procedure, this is going to happen, that's going to happen, that's going to happen. He's handcuffed the police officers are all standing around. This is the attorney-client interview. And with that, they take him before this judge, and what does Gaskins do? He waives the preliminary hearing. He claimed to me that Pitts and Lee wanted to plead guilty, which was ridiculous. They were holding out at that point and were not confessing. But he said, no, they wanted to plead guilty, and I talked them out of it. And I said, well, Pitts by this time has been beaten up very badly. Anything wrong with Pitts? No, he was fine. Nothing wrong with him at all. So he waives the preliminary hearing, and he tells him that you can revive the preliminary hearing later. I asked him all kinds of questions about, what, do you tell him not to talk to the police anymore, or anything like that? I said, no, I wasn't involved in any of them. So he was of no value whatever. So they went back. I could go on.
Yeah. So do they eventually get a lawyer named Fred Turner?
Fred Turner, yeah.
I don't want to cause you any grief. Tell everybody about Fred Turner, and you talk about this first guy being a zero. Fred Turner may be worse than a zero.
Yeah. Oh, absolutely. Yeah, absolutely. Fred Turner. Well, let me just tell you some good things about him, because y'all heard of the case of Gideon versus Wainwright. All right, that's the one to establish the right to counsel in felony cases. It rose out of Panama City, Florida. And when the case was sent back, after they reversed it because the defendant didn't have a lawyer, was convicted without a lawyer, he brought it back, and Fred Turner was appointed to represent this. This defendant was charged with burglary of a pool hall, and he was a white man. And Turner got him off and became kind of a national hero because of that. And then he got appointed to represent Pitts and Lee. And that's the bad part.
Tell us about him.
Well, they, of course, say they got a complete alibi. They got all kinds of witnesses that they don't want to testify to. The two Army CID investigators who are heavily involved in this case, and we can talk about this later, they were key witnesses in the case. They told him all about that, and he just said, okay. Then he sees them a second time, and he says, the only way I can help you is you've got to plead guilty, you've got to confess. It's the only way I have to save your life. And so...
no investigation, no investigation. Nothing, just
no motions.
No fight.
Nothing. No motions to suppress the confessions. The only evidence against these men were confessions.
Which were beaten out of them. Right. So Turner tells them, the only way I can help you is to plead guilty. How long had he been on the case when he tells them this?
About 2 days.
2 days. And then, so what do these fellows do? What do Pitts and Lee do?
Well, I mean, the judge had told them he was the best criminal lawyer in this area. And, of course, they were terrified. You have to understand that these men were terrified during the entire month. And I can quote to you from Judge Fitzpatrick, who was a trial judge. He said every time these men appeared before him, they looked like they were corpses. They were dead people walking. And I can quote you this thing, but he volunteered at a deposition I was taking. The deposition was over, and he had this on his conscience. And he proceeded to tell me all about this.
Phil, you know, one thing that has always, I think, troubled people that don't practice in the area that we practice in is, why, even if you're beaten, why would an innocent person confess? If you're innocent, why would you plead guilty? No innocent person would ever plead guilty. No innocent person would ever confess. For those who are non-lawyers and non-law students listening to this, how would you respond to that?
Well, if you were beaten up as badly as Freddie Pitts was, they took him out in the car to find the bodies, because they hadn't found the bodies yet. And they took him out in the car, and they spent all night looking for these bodies. Of course, Pitts didn't know where they were. He didn't know where they were because he wasn't involved in this thing. They beat the daylights out of them. There was this deputy sheriff from Bay County, George Kittrell, and he beat him on the side of the head with a blackjack for 10 hours. 10 hours, that's how bad. He could barely eat. He was in absolute fear of his entire life, that entire month. As to Lee, what they did to Lee was just as bad. What they told him was toward the end. They'd been interrogating him for a month. They told him, if you don't confess, we are going to take your wife out and shave her head and electrocute her unless you confess. They brought her out. She was in custody for nothing. I mean, she wasn't charged with anything. But they kept her in custody. They treated these people, David, like they had no rights at all. Not only Pitts and Lee, but the whole group.
And so this guy, Turner, tells them to plead guilty.
Of course.
And so 2 days in, do they follow his advice?
Well, they have no other choice. I mean, it was either that or, I mean, what are they going to do? They're just complete, and they're in total terror of their own lives if they don't do what their lawyer told them to do, so they do.
So they must have gotten some huge break, at least, that their lawyer promised them for pleading guilty. What do they get sentenced to?
Got death. He pled him guilty. Now, this is maybe inside baseball here, but no defense lawyer pleads a person guilty to first-degree murder without a deal that they're going to get life. He didn't. He had no deal. He never talked to anybody from the state attorney's office on this at all. He just threw him in. Now, you may want to say, why did he do all that? Why was he motivated?
What's the answer?
Because you have to understand, this was 1963. This was at the height of the civil rights movement in the South. And let me tell you, any lawyer who stood up for the rights of black defendants in the South was dead. He was, not only his practice was over with, his life was in danger. So that's, I mean, there's no doubt about, in my mind, he did it because he was afraid himself.
And just so everybody knows, this wasn't here in Miami. This was in the Panhandle. And as you travel north in Florida, you really get more south.
More south.
Right?
That's right.
And so,
very true.
You know, this is in the Panhandle of Florida during the civil rights movement.
Right.
Very difficult to represent a black defendant.
Especially one charged with murdering a white man.
So Phil, they're sentenced to death. You're a lawyer in Miami. How do you get involved in a case up in the Panhandle?
Okay, I got it through the American Civil Liberties Union.
Okay.
I was a member of the legal panel. I volunteered for services. I was working as an assistant PD here in Miami, but it was technically, I was working full time. But technically, it was a part-time job.
What was your salary at the time, just so people get a sense?
$7,500.
$7,500
That's a pretty modest amount of money. It's not end of the world wages. You could make a decent living at $7,500.
That's 1 month's rent on Brickell these days.
That's more like $50,000. So it's not bad.
Yeah.
But
so you, how do you? The ACLU contacts you and says, "Can you take this case?" Or
no, what I do is I was handling all the appeals in the office, and I wanted it. And well, all we had was non-capital cases. I wanted a capital case, and the ACLU had nothing but capital case appeals. So I said, "I'll take any one of them. Doesn't matter what it is." They sent this one over to me. At the time, it was not a cause célèbre. I would never have gotten it. I would never have gotten it otherwise.
And
then it broke open about a year later, year and a half later.
You get this file, two guys sentenced to death.
Yeah.
You had no idea what it was when you got it.
Correct.
And so we're jumping a little bit, but this is a file you have for the next 10 years of your life.
Right.
And it wasn't a case that you were able to break open just by yourself. You had the help of lots of folks.
Yes.
Could you just mention, I mean, to me in reading the book, two things were extraordinary. One, that you had the help of a Miami Herald reporter.
You don't
and two, that you had the help of a polygrapher. Can you tell everyone here about those two individuals who helped you out?
Oh, yes, my gosh. Well, we could never have won the case without them. Gene Miller was a Pulitzer Prize winning investigative reporter for the Miami Herald. His specialty was investigating known wrongful convictions. He loved to do it. And there's a long series of events involving Curtis Adams after he'd been, he got picked up for the murder in Fort Lauderdale. And when he got picked up for that, then it became obvious from the investigators that he not only had committed that robbery, but he committed the one in Port St. Joe as well. So consequently, you have to read the book to get all the details of it. But
good plug. Get the book.
Get the book, right. But eventually, they called in a private polygraph examiner named Warren Holmes, whom I had never met. I never known anything about him. And Warren was tasked with running a lie detector test on Curtis Adams' girlfriend, and she was charged along with him with the Fort Lauderdale murder. And so, but she said, "I want a lie detector test. I was never involved in this. He's the one who committed these murders. He committed some murders in Port St. Joe as well." So they want to see whether or not there's some merit in that. They bring in Warren. Warren clears it completely. He comes back to Miami. He calls me on the telephone. I never met him before. I didn't know who he was or anything. And he tells me that, "Are you representing these two men up at Port St. Joe, the murder?" I said, "Yes." He says, "Well, they're innocent." He says, "And I think I got the man who committed these murders. And I'm going to try to get him to confess the next day, or next couple of days," which he did. He went back, and he was a very clever interrogator. Because what he decided to do was, this man was a sociopath and a liar. But he decided to appeal to this man's ego. And he told him, the police really don't know who committed these murders. They think they do, but they're totally wrong. He says, the courts think they act, but they're all wrong. Only you really know the truth. Isn't that right? Now, this is a nobody. This is a guy in prison. He's doing, he's doing time, life imprisonment. So he says, not life. He got a life off of this case, but he's a nobody. And he builds him up. He says, you got a chance to do something good in your life. You got a chance to clear two people who are on death row for a crime that only you know that you committed. So why don't you, be a hero, in other words. Be a hero. And so Adams agrees. And it's in the books on chapter 12. It is a full confession to both murders in Port St. Joe and the one in Fort Lauderdale.
So this guy confesses. The polygrapher gets the confession. He calls you up. You file a motion. They get out the next day, right? There's a guy who confesses to the crime.
No. Anyway, he comes back. He contacts Gene Miller because the two of them work together, and Miller gets involved in the case totally. And he goes up and he starts interviewing all kinds of people. Pitts and Lee, everybody. And then he starts writing these articles about the case. And this goes on for 10 years.
That's when everybody got the Miami Herald delivered to their house. It meant something.
Yeah, that's right.
Nobody gets the paper anymore.
That's right, exactly right.
And we had these reporters who would dig into cases.
Yep.
He was writing front page stories about the case.
Absolutely.
And back then, newspapers could actually get the public interested and involved, right?
Sure.
And did that happen in this case?
Well, everybody in Miami was certainly behind us, but nobody up in, and of course, the police department, the sheriff's office in Broward was all with us as well, because they were convinced not only he committed these two murders, but no, we got no cooperation from the people up in Port St. Joe. And I was a little naive. I thought, well, look, I know they're prejudiced, I know they're bigoted, I know but they nobody wants to put two innocent people on death row and have them executed for a crime that we got the man who committed it. We got the man who did it. And so I tried to convince him, but I couldn't convince him. They were fairly nice about it. You know?
Well, they may have been nice,
but no, absolutely would never accept anything I told them about this case.
So they may have been nice about it, Phil, but you travel up there to Port St. Joe,
Yeah.
and it's a different world. And from reading the book, there are all these stories about how you and your team were attacked often by the judge, by the appellate court, by the KKK, by people putting spikes in by your car in the parking lot. I mean, there's crazy stories about, you know, these white Miami lawyers who had the nerve to fight for two black men up in the Panhandle. Can you? One of the stories. I mean, you were an appellate judge, obviously, on the 3rd DCA. One of the things that you do when you first appear in court at an appellate argument, a lot of people start out by saying, may it please the court, my name is David Marcus and I represent Phil Hubbart, right? That's a typical way to start out. You start out your argument in the 1st DCA, I know I'm jumping the gun, and how does the judge respond to you?
Well, I made a mistake. I did not identify myself. I was used to arguing cases in front of the 3rd District, and I was told by the chief judge I didn't have to identify myself anymore because
they knew you.
They knew me. I had 75 pending appeals. I was in court practically every day. So I got out of the habit. So when I got up in the 1st District to argue, I didn't identify myself. And then one of the judges yells at me, I swear you could hear it in the hallway, "Who are you?" And I apologized, I identified myself, and started going on. And
there used to be one of your colleagues, when he would get annoyed, would turn his chair around. Yeah. You remember him?
No, I remember him real well.
Yeah. There were some other attacks on you. Tell the story about the spikes on the car.
Oh, well. Yeah, you know, I was crazy in those days. I was afraid of nobody. And I was 29 when I got in this case. Looking over you, some of you even maybe about that age as well. And I didn't think anything really happened to me. So we came out after the first hearing in Port St. Joe, and we were getting ready to get in our car, and we noticed there were some spikes underneath the car. And I was the only lawyer there who didn't have any children. I was married but had no children. And the other 2 lawyers were the tremendous, one of them was just a fantastic lawyer, Erwin Block, one of the best trial lawyers I've ever had any pleasure working with. But they both had children, so I was elected to look under the hood. And I had no problem. I just went over there, opened the hood there. Well, there was no bomb, you know, or anything. But, you know, I look back on it now.
Spoiler alert.
I never would have done that in a million years. What is that, crazy?
Yeah.
You know?
What were you thinking?
I was invulnerable. I was 29.
So do you tell the judge that somebody had put spikes under your coat?
Well, the judge was right there. We called him over and showed him the spikes. Oh, he said some kind of prank. No,
just a prank.
No problem. Yeah, no problem.
You know, and so what I love, and just to take a second, you know, so many law school classes are getting away from storytelling and getting away from what I think is what makes the law so great. These kinds of stories and learning from stories.
Exactly.
And there's a push away from, you know, what we used to call war stories. This was a true war story.
Right.
But to me, this is the best way to learn about how to practice law. I mean, can you imagine going out to your car and seeing these spikes and calling the judge over and he says, "This is just a prank, don't worry about it"? It's wild. It's a crazy story, and it gets even crazier because this is a story I can't believe happened. So you file your motion for new trial. One of the central witnesses is flip-flopping back and forth about what happened. And the judge says, well, why don't we just hypnotize her in court? Can you tell us about the hypnotizing story and what the judge did? And
don't knock the trial too much, because Actually, we won.
Okay, fair enough. True, that the results are what matter, but
He was a strange guy, but he was a maverick. He was a Republican. And those
We'll forgive
days,
him.
Republicans were unknown in Florida. And he was a Republican. But anyway,
so the hypnotizing story.
Oh, the hip. Yeah, he wanted to have this woman, who they terrorized as well. I mean, they terrorized Pitts and Lee and this woman as well. They knew each other, were black. I mean, it was a sad situation, but they really threatened her with the electric chair and everything else, and she finally started to say what they wanted to say. So that's how they eventually. So anyway, the judge wanted to have her hypnotized, not just out of court, on the witness stand. On the witness stand.
So wait, but before we get to the hypnotizing, which is just crazy, so what was her initial story that was helpful to you that you wanted to bring out?
All right. When they finally broke her down, she then they brought in the state attorney. Now this isn't just a police investigation. The state attorney himself was brought in, and she made a statement to him that Freddie Pitts and another soldier named Lamson Smith had committed these murders, not Wilbert Lee.
Okay.
Okay. So, but then they couldn't get Lamson Smith to confess. So they went back to her and said, no, it's not Lamson Smith, it's somebody else. Now you got to tell us who the other one is. Oh, well, and she just made up Wilbert Lee. But they suppressed the statement blaming
the other
Pitts and Lamson Smith, and that's how we eventually got the new trial, actually. Because they suppressed that, but they not only suppressed that.
When you say they suppressed it, so everybody knows, so of course we all know under Brady they have to, the state has to give us favorable evidence, and when I say us, defense lawyers, and they never disclosed to the defense, of course Fred Turner pled him out in 2 days, but they never disclosed to the defense that her story initially pointed the finger at someone else.
Correct.
And so you're at this new trial stage and you're arguing, how did you even find out that her story had changed? How did you get this Brady information?
Well, that was at a time when I was in fairly good terms with J. Frank Adams. I asked him, and he said, yeah, we have a statement like that. And I said, can I have a copy? No, can't have a copy. Then later on, he denied that he had the statement. He said it was an oral statement. He didn't have it in writing. But fortunately, I had a very good contact with an investigator from the Attorney General's office who was involved in the case. His name is S.R. DeWitt, and he said, I've seen that statement. It is a written statement, and he gave it to us. Thank God we got that statement, because that's the basis on which we got the new trial.
So just so everybody understands, they get a new trial on the Brady information that's not disclosed, not on the fact that someone else confessed to the murder down in Broward.
No.
That's not enough to get a new trial, but we do get one from the hypnotized witness. So tell us, does she get hypnotized in court?
Yes, she gets hypnotized in court, and the hypnotist who puts him under admits that a person can lie under hypnosis if they're inclined to lie about when they're out of hypnosis. So there was no point in doing this at all.
You must have felt like you were on some other planet with a hypnotist in court. Did they do the watch thing where they say, watch this go back and forth?
But we felt we were winning the case with this judge. And we did, actually, because he gave us a new trial.
Did you object to the hypnosis?
Did I object to what?
Did you object to her being hypnotized in court?
Oh, of course, my gosh. And he said, and we could not cross-examine her while she was under hypnosis. We had to submit our questions to the hypnotist. And then the hypnotist would, of course, we did participate in that. That was idiotic.
You had a polygrapher, a hypnotist. It's interesting to me, the polygraphers, the police in the state always say if the person confesses and passes a polygraph test, it's okay. But if they, if it's helpful to the defense, you can't rely on these polygraph exams. I mean, they're rarely admissible in court. Do you think polygraph exams are reliable and should be admissible?
No. It all depends on the operator. If the operator knows what they're doing, if they're a good interrogator, they can, I think, be helpful in getting a true confession out of somebody. But no, I mean, it all depends on the operator.
So you get this new trial. At that point, is there a celebration for you, Pitts and Lee, and the other lawyers, or is it, man, we have to retry this case now? Is it going to be in the Panhandle? Tell us a little about the reaction after the new trial.
Well, in the first place, the state appealed it.
Okay.
And they appeal it to the first district, and the first district reverses it. And in an absolute abortion of opinion, in which the judge violated all the rules of appellate practice by one of the solid rules is that if a case comes up after a full hearing and testimony and so on, and an order has been entered on it, the presumption is that it's correct and that all evidence which supports that has to be accepted. If there's any conflict in the evidence, those conflicts have to be resolved in favor of the testimony which supports the order. Well, what this judge did, what the court did, was they picked stuff out of the record that they thought was favorable to a reversal, and they also picked testimony out of depositions. And the judge himself said, I'm not relying on the depositions. So they reversed it. But they did certify to the Supreme Court of Florida. So now the Supreme Court of Florida gets the case. And meanwhile, we get a new attorney general, one of the real heroes in this case.
Tell us about him.
Bob Shevin.
Bob Shevin. He's an important player.
One of the heroes in this case, along with Gene Miller, along with Curtis Adams. I mean, no, Curtis Adams.
He's the villain.
No, he's the villain. No, along with Warren Holmes. And so...
Shevin, how does Shevin get involved?
Shevin confesses error. He confesses that we were entitled to a new trial because the state had suppressed evidence of innocence, namely this statement in which this other person had confessed to the crime, and that's the only reason we get a new trial.
So, Phil, I love criticizing prosecutors, and I'm the first to do it. And it kills me that in this case they were fighting you for so long about a new trial, about doing justice. It just blows my mind. But we should celebrate when prosecutors do the right thing. And here we have Bob Shevin coming in. You've lost in the first district now.
That's right.
It would have been easy for him to say, I'm leaving it to the courts.
Of course.
And not step in. Here's the Attorney General, a new Attorney General,
right.
who comes in and says, listen, we messed up as the state. We should have disclosed this information, and they should get a new trial.
Right.
It's pretty incredible, especially during that time period when a new Attorney General who has political aspirations, I imagine,
sure.
comes in and does that. But by the way, does this ruin his political career?
Absolutely. That and the fact that he eventually voted for the pardon. Now, we should mention that Pitts and Lee were eventually pardoned by the governor and by the Florida cabinet on the ground of innocence.
We're going to get there. Don't jump the gun. Don't brew it. Don't spoil. We're going to get there. We're going to get there.
But I mean, we're talking about Bob Shevin throwing away his political career for a principle.
Was he a Miami guy or?
Yes, he's from Miami.
See, we need more Miami guys as important figures in Florida.
I knew him personally. He was a good man.
So the Florida Supreme Court agrees with Shevin and agrees that there's error, sets the new trial.
Right.
And it gets reassigned to a new judge for trial, no?
Yeah.
Tell us about the new gentleman who gets the case.
Well, the guy who gets the case is wonderful. He's John Cruz. He was from Gainesville. I think he was originally from somewhere in the Panhandle, but he moved. And he was a circuit judge in Gainesville, and he gets assigned to the case by the Supreme Court of Florida to try the case. He hears a number of motions that we have, one of which is a motion to dismiss the indictment on the grounds that the defendants had been indicted by a grand jury which had been drawn from a venire from which eligible black voters had been systematically excluded. And the judge grants the motion and dismisses the indictment. Of course, they were allowed to re-indict the defendants if they could get a new, and of course that's exactly what happened, got re-indicted. But as a result of the judge granting this motion, I think he got some he got some political heat off of it, and he withdrew from the case.
So who does it get reassigned to?
And it was then assigned to a judge called, from Ocala, called D.R. Smith, David Smith. And he was, more connected with the political structure up in that area, and he certainly was no John Cruz at all.
And where does the case end up getting tried the second time around?
We filed a motion for change of venue. And Judge Smith hears this motion and he grants it. And that's another thing about this case. It's a lot like the Shakespearean tragedy, King Lear. There were a lot of false dawns. A lot of false dawns where, oh, we got a new trial, this is great, we just got to get it out of this area and then we'll win. So we filed this motion, he grants it, and we're just celebrating. And he then says, come back in chambers, and he says, I'm going to move the case to Mariana. Now, Mariana was about 70 miles from Port St. Joe, in the same judicial circuit, in which this case was notorious. Everybody in this area, the Panama City News Herald had been writing a whole series of news articles and editorials against us. They were us against them kind of editorials. These NAACP, ACO lawyers from Miami have come on here and creating all kinds of problems and so on and so forth. And they were really vitriolic.
You know who was happy about the change to Mariana? The KKK probably was thrilled about it.
The KKK had actually a rally through the black area of Mariana about 2 or 3 weeks before the trial. So he just moves it up to Mariana. So of course we move it again, try to move it again out of Mariana, and he denies it. We took 12 days to pick a jury, 12 days, 12 working days. And every single juror came up with very few exceptions, knew all about the case. They knew all about the case. And they had heard opinions that they were guilty, it was a waste of time to retry the case, et cetera, et cetera. But this judge kept saying, no, they really don't know anything about this case. And so I don't know what courtroom he was in, but I mean, there was no doubt in my mind that we had no chance at all. So what we had to do, David, is to lay a ground for appeal. We knew we couldn't win the case.
It's funny because there are some lawyers here who we know when we're in front of a judge who just is ruling against us every time, all you can do is fight and get ready for the appeal. That's all you.
We got to lay a ground for the appeal.
That's all you can do. And so
that's what we did.
I mean, when I was in law school, one of the hardest things was evidence for me, learning evidence and all the rules, and I couldn't figure out there's an exception to the exception to the exception, but I knew at the end of the day the rules were meant to try to have fairness in a courtroom. That was the end result.
Right.
And so here you have a confession from someone else confessing to the crime. So that should be admissible in a trial against two folks for murder, right? That someone else confessed. How many of you, if you're the judge, allow the confession of someone else into evidence? How many let it in? So did this judge let it in?
No.
What happened?
Well, he didn't understand our argument. This is where we long to have Judge Cruz back. It was hearsay evidence because it was a statement made by an outer court declarant introduced to prove the truth of the matter stated. But there was an exception to the hearsay rule that we were relying on, and that was,
I think it comes in under a lot of different exceptions to impeach and so forth. But
well, no, we were relying on a declaration against interest.
that's a good one too.
A declaration against interest. He says, unfortunately, in Florida, that had only been applied to declarations against the declarants, that is, the out-of-court confessors, financial interests, but not their penal interests. But I have a raft of cases from other portions of the country, other courts, saying that it should be extended to penal interests as well. The judge he was absolutely convinced that there were no exceptions. If it was hearsay, that's it, it's out. And he even took a recess on thinking about it, and then he came back and said, no, the state had no opportunity to cross-examine the statement, and therefore I'm not going to allow evidence. Well, of course they didn't. I mean, it's hearsay, but we're relying on an exception. He just doesn't understand it at all.
So the confession of Adams does not come in.
Right. And all the evidence, his escape from Fort St. Joe right afterwards, and his commission of a similar crime 16 days later, the exact kind of crime, similar crimes evidence, that was excluded too.
It's really jaw-dropping.
And the statements, I'm going to interrupt you, David, but also the statements made by Curtis Adams to his girlfriend on the night this happened and the night after. All of that was wiped out. Of course, to tell you the truth, even with that evidence, we never would have won this case.
I'm not so sure about that. I mean,
well, we might have hung the jury, though.
Exactly. You might have hung.
We might have hung the jury.
By the way, hanging a jury in this case is a victory.
Yeah, of course.
But it gets worse than that, because then we get to closing arguments. And, you guys, you and Block argue the evidence, of course.
Yeah.
The prosecutor gets up and tell us a little about the prosecutor's argument.
It's a classic us against them argument. He said, let me tell you what these people are trying to do. They're telling you that the panhandle is bad, that all the people here are bad, the police are bad, the judges are bad, the lawyers are bad, and one of the jurors is nodding. This is happening.
That's also bad.
Now, the only evidence they got are confessions. That's it. No physical evidence, nothing. And also, I could go into a lot of other things as well.
So this closing argument, us versus them, you guys must have been popping out of your seat. Absolutely. Objection.
Like mad.
And what is the judge doing?
Overruled. Proven from mistrial. But we had to do it to preserve it. If we didn't object, we waived it.
You have to object.
I objected.
And do you... I'm always curious about the strategy here in trial cases, because you want to win the trial, of course. And if you're objecting and it's overruled, does the jury get a sense like, the judge is with the prosecution also?
Yeah. You never know exactly how that's landing with the jury, But I think jurors respect the fact that this guy's a fighter. He's in there pitching away. He's got something to argue about. I think they respect good lawyers.
And so how do you respond? But by the way, the rules in Florida used to be a little different. So it used to be that defense lawyers could give the initial close and the close, the rebuttal. Yeah. They changed that a few years ago. They took away one of the advantages that the defense had.
Right.
But you guys had the initial and the rebuttal close.
Right.
So after the prosecutor gets up and really, makes you the villain, how do you respond to that in your rebuttal?
Well, it's the only argument I made that day that I thought I connected with a few of the jurors. And I said, we've listened to this long argument by the prosecuting attorney, Leo Jones, and never once has he mentioned the statement that Willie Mae Lee, their key witness, said in a sworn statement to the state attorney himself, that she knew nothing about this case, and that Pitts and Lee are completely innocent of these murders as far as she was concerned. Never said a word about it. And for that, I said, can he guarantee you that Willie Mae Lee is not sometime in the future going to come back and say, you know, the people, the testimony that I gave to those people in Mariana, that was a lie, it's not true. Can he guarantee that that's never going to happen? I think I had a few jurors. That's the only time I thought I connected.
I jumped the gun a little bit, Judge, because one of the things that always really interests me about trial tactics and strategy is whether to call the client to the stand or not.
Yeah, right.
And can you tell us a little about whether you called Pitts and Lee to the stand in this trial and the thinking that went into that?
Oh, well, I'm a firm believer, with, of course, some exceptions, naturally, but I'm a firm believer that the jury wants to hear from the defendant that I am innocent of this crime. I did not commit this. They want to hear that. The only time I think that it's probably not a good idea to call him is where the defendant's made a full statement to the police in which he says, I'm innocent. Because if it's a good statement, why risk the chance of putting him on the stand? Because he might get mixed up with something or other. But I think they want to hear that. Now, sometimes, of course, you can't do it. It's impossible.
Did you do it here?
Sure, we put them both on because they're great witnesses.
And they did okay?
Yeah, they're terrific. My gosh, Lee practically came out of the witness stand. And when Leo Jones tried to cross-examine him, he said, Mr. Jones, you'd have done the same thing as I did. If you were in my shoes, you would have done the same. They were threatening my wife. If they were threatening your wife, you'd have done the same thing too.
I just got goosebumps here.
I mean, I don't think Jones understood. He thought he was dealing with an Uncle Tom. And this guy was no Uncle Tom. He may have looked that way, but he wasn't. He got radicalized to some extent in jail too. Anybody would have been, because he was so sincere. He cooperated with the police. He told them everything. He did not try to escape. When they let him go, for a while. That's when they blamed Lamson Smith. They let Lee go. He went back home. Did he escape? No. He just stayed there. Then they went and grabbed him and his wife. This is what infuriates me about this case, is that they not only denied Pitts and Lee their rights, but everybody else who was associated with it. They locked them all up, including Willie Mae Lee. Willie Mae Lee was their key witness. They kept her in jail until Pitts and Lee got the death penalty. Then they let her out. She was a so-called eyewitness.
And then she was in jail.
She was in jail, and our alibi witnesses were in jail. I mean, what kind of a world are we living in?
So let me talk about maybe the lowest point in the case before we get to the highest point. The verdict comes in that night after closing argument. It's not good, and you know it's not unexpected, of course, because of where you are and the argument to the appeal of these outsiders attacking us. So the verdict comes in guilty, and one of the things that you mentioned, Erwin Block, his wife was there to see the verdict. And tell us about what happens when the verdict comes in and what she does.
Oh my God, this I have never witnessed anything like this in my whole life. But Erwin Block's wife, Doris Block, and my wife, Martha, had listened to the entire trial. They were friendly with one another. They were listening to they were in the audience, and they listened to the whole trial. Both of them are Southern ladies, very quiet-spoken, respectful of everybody, really nice people. When Doris hears that death sentence, she stands up. She's sitting on one of the seats with the aisle which led into the well of the court. She stands up. She runs into the well of the courtroom and points her finger at the prosecutor and the judge. He says, I hope you have this on your conscience until the day you die. And ran out of the back of the courtroom. The judge comes to his feet, partially. I thought he was going to have a heart attack. His face was wet. In fact, he did have a heart attack a week later, and he almost died. that's another strange thing about this case. I think at that time, he really did feel as if maybe these people are innocent. Maybe these people were innocent. And he just sentenced them to death. But he did recover. And then Irwin, who of course had a very sardonic sense of humor himself, he turns to me and says, "Good for her." Good for her. Good for her.
So one of the lowest points, obviously, but then we get to the end, which is an amazing result, which is they end up getting pardoned. And I want to talk about another hero in the case who's now a federal judge in our district, Don Middlebrooks.
Yeah.
At the time, Don Middlebrooks was working in the governor's office.
Right, he was.
And he's asked by the governor to go look into this case.
Right.
And what happens with Middlebrooks?
Well, Middlebrooks was able to contact Pitts and Lee, talk to them. He got very upset about the case. He believed them. He went back, he talked to the governor, he talked to the governor's council. They went out to see Mary Jean Akins, who was the girlfriend, who was still giving the same story that Curtis Adams had confessed to her on the day of on the night of the murders, the night after the complete murder. And then he comes back and he is able to contact Curtis Adams. He talks to Curtis Adams and comes by, and I guess he talked to the governor about all of this. So yeah, I mean, he did play an important role, I think. Of course, there were other factors as well.
Of course.
I mean, Chris Barquette, who was the nephew of Jesse Burkett, one of the victims in the case, one of the murder victims, became convinced that these men were innocent and went to the governor and told him so.
Hero in the case.
Amazing to me.
So,
I mean, it's the most incredible case I was ever involved in, David. I mean, I don't want to give anybody the impression that's just a routine case in Florida. This is the most important case I was ever involved in.
10 years!
10 years of my life. But I was so mad at these people. I'm still mad at them.
I can tell.
I'm still mad at these guys.
So you're angry. Let me ask you, Pitts and Lee get pardoned, they get out. Are they angry too, or how do they react?
There's a certain bitterness. Both of them had a certain bitterness, but they told me they did not let that bitterness destroy them. They did not let them destroy them. And Pitts actually, well, both of them were very grateful to all of the white people that helped her get out of this mess. He says, Pitts, I quote Pitts in the book, saying that it would have been easy to come out of prison hating all white people. He says, but actually it was white people in the system that actually saw that justice was done. So the man had a balanced view of things. He had no record, by the way. He never been arrested in his life. Peace. I mean, it's just beyond me. That's why I could not write this book about this case until 2010. I was so angry, and I gave speeches on it. I could give an impassioned speech on it like I'm doing now, but to sit down and write about it, that's a different story. And
it was a great story. Do they get compensated in any way? Do
Yes.
they get made whole? I mean, obviously you can't get made whole after 10 years on death row. Yeah.
They went to the state legislature every single session until 1998. 24 years asking for compensation. Now, if these people had been guilty, they'd have said, hey, we got away with murder, we're just going back to our life. They kept going to court. They wanted some money for what they had done, and eventually the legislature gave it to them. $500,000 apiece in 1998 was finally awarded to both of them, and Governor Lawton Charles signed the bill, and they both came back to Miami. They lived productive lives. Pitts was involved in his own business as a trucker, and Lee, of all things, worked as a rehabilitation officer for the Dade County Jail.
Wow!
And retired. They both died. I'm one of the few people that are alive in this case, and I'm a little up in the years. I'm 87. And when you get to this age, you get to be a little forgetful at times. And I'm afraid I was a little bit, David, and I apologize.
You did great. My dad used to say, "I'm in great shape for the shape I'm in." That's what he used to say. So I think the students may have some questions for you if we can take them. But I just want to, before we get to the students, just thank you for putting the devotion, the energy into the case itself, into telling the story. It's such an amazing, important, scary story from our history, and it's one we need to know about. And so thank you, Judge Hubbart, for doing this. Seriously. So let's take some questions if you all have some questions for Judge Hubbart. Here's one over here.
Yes, sir.
Yes, Judge. My question, when you were talking about... Hold on.
Oh, good.
Yes, Judge.
I'm a little hard of hearing, so speak up.
Yes, Judge. Okay. My question is, you said that they were nice about it. The judge, after I believe it was the appeals court, after you were asking them, you said they were nice about it, but they said no. Were you nice about it? Were you nice about it?
Were you nice?
Were you nice about it, Judge?
Were you nice to after he found out about the result, or when?
I believe this is at the appellate level.
Oh, were you nice to the appellate judges when you found out about their decision?
Nice to the appellate judge.
Were you
not necessarily nice, but my question is, were you more professional, or did you really push the topic?
Did you keep your professionalism during the case?
Oh, yeah, of course, sure. Yeah, that's one of the things that you learn as a defense lawyer, and that is you have to display a certain respect to the court and to opposing counsel and to witnesses. I mean, you're not going to get anywhere with the court or with the jury by attacking people and being nasty. Well, there are some lawyers who do that, of course, but they're not very effective. I think the ones that are effective are the ones who stay within the rules. And so, of course, that's exactly what I did.
Who's next?
There must be some other questions.
Here we go in the back here.
Thank you, Judge. I was wondering, you battled this case for 10 years. Was there ever a point where you felt that there would not be success in the end, or did you always have the foresight that you would win the case? And just, if you could explain.
Did we ever get discouraged?
Yes.
Never got discouraged. Absolutely convinced we're going to win this case. And you got to understand, at this time, we had a Supreme Court that really defended people's rights. We had the Warren Court. That's the most liberal court we ever had. Now,
the fairest court, not the fairest court.
Absolutely. Gideon versus Wainwright, all other cases came with them. So we knew that we were going to win this case when we got into the federal courts. We were going to lose in the state courts. We understood that. But eventually we were going to win this case. And besides that, we were fighting for justice. We were standing up and fighting for what was right. And that's the great thing about being a lawyer. A lawyer, most people got to sit on the sidelines and watch bad things happen to other people. But a lawyer's different. A lawyer's got access to the courts, and the lawyer can stand up and fight for what's right. And that's what we did. We stood up and we fought for what was right. And we were never discouraged. Absolutely never.
I don't know if you guys, I mean, that is so incredible what you just heard. And, it inspires me. I've been doing this not as long as you, Judge, but for 25 years. And it's true. I mean, the beautiful thing about being a lawyer, especially a criminal defense lawyer,
absolutely,
is you can get up and fight for someone and be their champion. And it's a pretty rare and great thing to be a lawyer and a criminal defense lawyer. I know we have prosecutors here too. and you can do the same thing. But I'm biased, so I'll say be criminal defense lawyers.
Yeah.
Over here.
Hello, Judge. I just wanted to say thank you for coming out today and for speaking with us.
Hold on. Hold on.
So, thank you.
Too close.
Too close.
Yeah, I can't be away from, you got to stay away from the TV.
Do I take it?
Yes.
Okay. So I just wanted to say thank you for coming in and speaking with us today. I just wanted to know what it was like to put all your thoughts, all these memories onto paper after so many years. What was it like to relive this, for a second time?
What was it like to write this story after so many years, emotionally and everything else for you to write it down?
Well, what really helped was I was still mad to a certain extent, but not nearly as mad as I was at the time. I mean, I was so angry at these people. I could give an impassioned speech about it like I'm doing now, but I couldn't really write about it. But I joined a writers group, and it was an excellent group. I really got great feedback from them, and I tried to write the first chapter of the book, and I got some terrific feedback from them. And I made some revisions. They went back, and I had the help of that group. I think without that group, I don't think I could have done it. But I lost a lot of the rage, and I've always been very detail conscious. I've always been very detail conscious. So writing footnotes and writing and looking up transcripts and all of that, I like to do that. And that's what I do as an appellate judge, of course. You're very detail conscious as an appeals judge. You're writing opinions, you're reading transcripts, you're reading briefs. I was very good at that. But this class helped me enormously because it calmed me down a lot, and they wanted to know this and what about that, and you didn't write about this, and we don't understand what this means. So I couldn't use any legal jargon or anything like that, and that helped me tremendously.
Sometimes
it took me 4.5 years to do it, but I mean that's.
But sometimes it's cathartic to put it on paper and let the rage out on the paper.
And it's like I was reliving it.
I bet.
Reliving the case.
I bet.
Yeah.
I bet.
Yeah.
Who else? We got here and then here. Or maybe we could do this, Scott. Just turn this around.
Okay, you got it?
Yeah. Here.
Yeah, just put it there and then they cover for anybody else. You ought to be running the park.
Hi, Judge. Thank you for being here. You mentioned throughout the story that the case was reassigned to multiple judges. Some of them were more fair, some were more bigoted. How did you take that experience into your career as a judge?
How did you take being in front of all these different judges into your career as a judge? Some were bigoted, some weren't, some were fair, some were hypnotizers. How did you take it into your career?
Yeah. Well, I tried to be the kind of judge that I liked.
Appearing before.
Or what I liked appearing in front of. Judges that were fair, that were interested in listening to both sides of the case, and I loved oral arguments. I was able to ask hypothetical questions. What about this? Well, if we change the facts of this case, that what are your views on this, and what are your views on that? I tried to, and I did it not just to be fair, but I was really trying to reach the right result. And so I think basically what I learned from that experience was to try to be the kind of judge that I liked when I was a lawyer.
Here we got a question here.
I was just curious, to what extent were you involved in helping these two men get their compensation afterwards? And was that number, I assume they weren't happy, 500,000 for 10 years just seems like it's a very low figure. Were they advocating for more, or was that basically what the legislature was through at the time?
So the question is, did you help Pitts and Lee with their compensation before the Florida legislature?
No.
And the number itself seems like it should be higher. Were they asking for more money, or how does that work?
Yes, they were asking for $1 million, and at the last minute, it got changed to $500,000. I had nothing to do with that. I was on the bench at the time. Well, I'd gotten off the bench in 1996. This happened in '98, but I was not involved in that whole struggle from 1976 on. They had lawyers, excellent lawyers that had also members of the Dade delegation that introduced these claims bill every session of the Congress, of the state legislature. But I was not personally involved in any of that.
Was the ACLU paying you for your representation during those 10 years?
No. I was on a state salary. I was a public defender.
Oh, right, $7,500.
So,
right. I got you.
There was no problem about compensation or anything.
Well,
That was the whole compensation issue. Yeah, you think $500,000 is rather minor for 12 years of wrongful imprisonment, 9 of which are on death row. Yeah, I mean, you would think they're entitled to more money than that. But you know, how many defendants actually get any money for this? There's lots of people that are now released from death row and are released from prison. And sometimes have been there for 20 and 30 years who get zero, nothing. It was fortunate that these men got anything. And, but they were so persistent. And that's because they were innocent. And they were not going to give up. And I give them all the credit in the world. Because they stood up and fought for what was right as well.
so I just want to end here and say, you know, you guys have seen something truly special today. You're so lucky. Dean, thank you for doing this. HT and Scott, for this series that you all do here at the law school with legends like this. These are stories that must be told. These are stories that you are so fortunate to hear. Law students around the country are not hearing these important stories, and you all are so lucky to have a faculty that supports this kind of storytelling. And most of all, thank you to Phil Hubbart for fighting for Pitts and Lee, for getting them off of death row, for coming here and telling this story. It's unbelievable, and thank you for everything that you've done, Phil. I want to take a second and thank Florida International University School of Law, as well as H.T. Smith and Scott Fingerhut, for putting on a terrific event with this legend, Phil Hubbart, who is not only a legend here in Miami and in Florida, but is living a true legacy with all of the folks he's mentored, all the public defenders and lawyers who have carried on the torch and fighting the good fight. My name is David Oscar Marcus, and I want to thank you all for listening to For the Defense. We'll be back in 2 weeks with another episode. Thank you again.